Good day, everyone. Welcome to Fasken's 2022 mining series. This is the 12th year that we've been doing these. I'm Michael Barassa. I'm in the Toronto office of the Global Mining Group. Today's session is our 7th of 15 total sessions that we're doing this year. There is a slide, I think, that's up there right now, just at several housekeeping items, such as doing the survey and so forth. So please have a look at that. And with that, I'm going to turn it over to my colleague, Karim Maalioun, who's going to introduce today's panel, which is on Ohada and mining projects in that region. Take it away, Karim.
Thank you very much, Michael, and greetings from Bamako, Mali. I'm Karim Maalioun. I am an energy and mining partner at Fasken. I'm based out of London. And today it's a real pleasure to share the discussion on mining project in the Ohada region, but from a specific angle, which is going to be the dispute resolution angle, and in particular arbitration. We obviously do not measure yet the impact of the war in Ukraine on the mining assets or the projects in Africa in general, but we'll certainly discuss it during this section. To speak about our topic, I'm really pleased to introduce our prestigious panelists to the audience. First, we have the pleasure to host Jean-Claude Diplo. Jean-Claude, welcome. I know that you are currently in Abidjan, Côte d'Ivoire. So welcome. Jean-Claude has several caps, I would say. He's a country manager for Groupe Alid Gold Corp in Côte d'Ivoire, and at the same time is the president of the mining chamber in Ivory Coast in Côte d'Ivoire. I would say that Jean-Claude has many links with Canada. First, he's an HEC Montréal MBA alumni. And second, he has been involved in the Canadian investments in West Africa as commercial delegate. He's definitely a seasoned manager with more than, I think, 20 years of experience in the mining sector. He has had several, and is still actually a director in several mining companies, including Bonikro Gold Mine, Agbao Gold Operation, which are all belonging to the Allied Gold Corp. Finally, I believe that Jean-Claude has been appointed as the president of the Groupement des Professionnels Miniers in Côte d'Ivoire for the next 3 years. So really congrats, Jean-Claude. Thanks a lot for being with us. It's really great to have you as a mining developer and operational person. I'm turning now to Achille. Achille Ngwanza. I mean, Achille is a well-known Ohada arbitration specialist. He has had the pleasure to share with us a former panel. I think it was 2 or 3 years ago. Achille is a doctor in law and is qualified to the Paris bar. He's teaching oil and gas. He's teaching mining law and in particular arbitration law in various European and African universities. As I said, you know, is really an expert on mining and I would say extractive business sectors. He's experienced with the ICC, with the ICSID, with the UNCITRAL, with obviously the Ohada CCGA. Is a member of the ICC International Court of Arbitration and the Mauritius Chamber of Commerce and Industry Arbitration and Mediation Center. And last but not least, is chairing the Ohada working group at the Comité Français de l'Arbitrage, and he co-chairs the African Arbitration Group of the International Bar Association. Achille, once again, thanks a lot for having you among us. It's always a pleasure to discuss with you on this issue. Finally, my fellow partner, Peter Mantas, and Peter is sorry, I forgot to say that Achille is currently in Niamey. So we have Jean-Claude in Ivory Coast, in Abidjan. We have myself in Mali. We have Achille in Niamey. And Peter Mantas, who is currently not in Africa, but in Ottawa, is our senior litigation partner and is acting on very high-stake matters, nationally, but also internationally. Is the leader of Fasken Procurement Group. He co-leads the White Collar Defense and Investigation Group, and is really one of the litigation arbitration leaders of Fasken. He is based out of Ottawa and London, and he has been involved, obviously, in African matters, and in particular arbitration matters involving Ohada law countries. Peter has been recognized by chambers, a lot of professional ranking magazines. Is a member of the New York and Ontario, and in 2020 has been inducted as the fellow into the Litigation Council of America. Peter has been nominated in Canadian Lawyer, a magazine, as one of the most influential lawyers in Canada. Welcome, Peter. Thanks again for being with us. And it's really fantastic to have all of you sharing your experience with us. Now that these introductions are made, let me tell you a little bit about how this session will work very quickly. There won't be any formal presentations by our panelists. Rather, I will ask some questions to a panelist so that we can get some tips from their own experiences. This will last approximately an hour or so. We will have then a question and answer session for 20 minutes or so. And finally, I think everybody wants to go in weekends, in getting one key takeaway from each of the panelists. So I will ask each of the panelists to basically provide the audience with a takeaway. Before getting into this question, I think and not knowing exactly, whether people in the audience in particular was or is familiar with Ohada, I think that as a reminder, I felt I needed actually to remind people what was Ohada. For the audience and for people who do not know, Ohada is literally a system of law and implementing institutions that has been adopted by 17 West and Central African countries in 1993. So the Ohada is basically the acronym for the Organisation pour l'harmonisation en Afrique du droit des affaires, which is the organization for the harmonization of corporate laws in Africa. It has been designed initially to attract foreign investors by literally strengthening the legal and the judicial security in the Ohada law countries. This Ohada organization basically is governed by literally 10 Ohada Uniform Acts, which were enacted with a view to, as I said, offer a favorable environment for the businesses and an efficient regulations to investors. These uniform acts, are covering different domains of the company's economic life. It relates to commercial companies. It relates to securities, in particular when you do financing and you take security on assets or shares or other assets, protection of the minority shareholders. But right today, we will really be focusing and interested in the Uniform Act that is related to arbitration. And before going into this question, it's clear that the context of the disputes in the mining sector is multifaceted. I mean, as you probably all know, mining investments, often face political risks. I mean, we're hearing every day, this resource nationalism vocable, and it's true that this resource nationalism can lead to political decisions that sometimes, directly affect the mining company, and this definitely could lead to disputes. So this mining project, given that they're strategic projects, they're particularly sensitive, and they're also sensitive to market fluctuations, which can obviously affect the project and lead to the suspension of mining operations. And obviously, there may be a lot of conflicts arising between the mining company and the state that result from a distortion between the exercise on one hand by the state of its sovereign prerogatives and the guarantees that were granted to the investor. We're receiving as law firm a lot of questions about, okay, how we can settle this dispute, whether we need actually to go in front of courts, in front of the arbitration. We'll see during this panel session whether the arbitration is always possible by law, but it's clear that today arbitration is seen by our clients as a privileged means of settling the dispute in the mining sector. Therefore, drafting the proper arbitration agreement has become not only typical in this contract, but absolutely critical in how to draft them, assess them, including when you, in particular, are on the transactional front and you need to defer this specific sections to litigators and people who are really, really experienced in dealing with this sector in Africa, at least in the Ohada Law countries. Okay, so I think I spoke probably too much as an intro, but I thought that I wanted to, that I needed actually to give you that type of reminder. Let's get into the topic, and perhaps as the first question, what I would like to know, and perhaps the audience, what's the market right now? I mean, what are the Ohada arbitration trends versus the other types of international arbitration involving an Ohada Law country? What do we see? Are we still seeing the contracts governed by ICC, or are we seeing more and more contracts and mining contracts governed by Ohada arbitration laws? So perhaps, Achille, you want to start?
Yes, why not? Thank you for giving me the floor. First of all, I want to greet all the attendees, all the panelists. It's my pleasure to participate to this webinar one more time. Even 2 years ago, it was in person. It was the last event organized before the COVID pandemic. I also remember Karim will have a good time in Toronto. With regard to your question, I will address it on three approaches. First of all, we're talking about arbitration agreement, and you're talking about also some trends in terms of law and in terms of case law. With regard of arbitration agreement, I will adopt a wide scope because we don't focus only on contract, we talk about only also of BIT. With regard of BIT, we see the growth of the insertion of CCGR in BIT as a way to settle investment dispute. And this is in compliance with what the Ohada lawmaker made 5 years ago during the amendment of the Uniform Act on Arbitration and CCGR arbitration rules. During this reform, the lawmaker include a provision which state that for the settlement of dispute on basis of BIT of any national statute, you can seize the CCGR. Now, in practice, we haven't seen yet any arbitration proceeding on the basis of a BIT. But concerning contracts, what we can see that in contract concluded by state entities, they are more in favor now to insert arbitration agreements which focus on CCGR. Even in ICC statistic, we see the growth of the dispute, the number of disputes involving African parties, in particular of Ohada area. What we can say that CCGR is growing, even the speed is not too high. We see in many contracts now concluded by state and city, it's very easy for them to include CCGR. Even some investors still reluctant because they don't have a good knowledge of Ohada arbitration system. We see that the things are changing. even they are going step by step, we see a new trend. With regard of case law, what we can say in general, because we don't focus on the case law, there are many decisions. What we can say is that the Ohada system is in compliance with the international standards in terms of competence, in terms of setting aside awards, in terms of enforcement of awards, but it remains some particularities will give a competitive advantage to Ohada system. In terms of enforcement of awards, when you have a CCGA, an award, the writ of execution is issued by the chairman of CCGA, and this writ of execution is covered for the whole countries members of Ohada. That means if you have one award, you can be enforced in 17 countries without asking for each country a writ of execution. I think it's very important when you have a dispute with a company involved in many Ohada countries, just one decision. So in terms of trends, we can say the Ohada system is growing. In comparison with ICC, the main difference between ICC and Ohada is what I said about enforcement of award. Because when you have an ICC award, if you want to seize the asset of the filing party in an arbitration, you have to make several proceedings. If you want the asset are in 7 countries, you have to launch 7 proceedings. But in Ohada award, just 1 proceeding, and you go for each country, get the stamp of the national authorities to make any collection of your asset.
Thank you, Achille. Jean-Claude, what's your views? I mean, I'm sure you're discussing a lot with the mining companies and obviously with the Minister of Mines. I mean, is there a kind of consensus, or are we going to a consensus whereby, the Minister of Mines, for example, will never sign again a mining convention unless and until the dispute clause is regulated by the CCGA? Do you think arbitration, do you think this is something we are going to, or is it we're not yet there?
Yeah, thank you, Karim, and thanks again for the opportunity of attending, participating into this panel, which will certainly not only learn for ourselves, but also an opportunity to share experience we might have in this part of the world. I was listening to Achille very interestingly, looking at the trends at Ohada from arbitration perspective, and it's good to see we're still in a very young process. I should call it this way. I wouldn't say it's so both the arbitration process from Ohada and the mining sector in Côte d'Ivoire are yet in the still infant time, call it this way. So the process is just maturing now. So yes, there has been some increase in the number of cases being taken into arbitration from the Ohada perspective, but from the mining sector as such, there is still, the trend is still dominated by international arbitration platforms. So you still see in most of the mining conventions, the preference will be for ICC or others on the international scene, which is, understandable, from mining companies' perspective. So, and there are various reasons for that. I think it is, as we grow, it will be important for the sector to take on board, call it the marketing perspective in terms of selling a little bit more the Ohada options that are available on the market. They do present a lot of attractiveness. Ohada arbitration will prove less expensive. That's a fact. Ohada arbitration will prove more diligent. That's another fact from what we're observing. However, because the mining investors are from the international platform, they are used to international arbitration systems. But also, you look at the arbitrators frame list itself. Yes, there has been an increase of the arbitrators available in this part of in the Ohada system, but you still have to find very dedicated expertise, very specific expertise in those arbitrators to handle mining disputes should that arise. So I think these are part of the reason why we are not seeing this huge change or turnarounds as of now. But definitely, this is a conversation that is starting. And your question was, will the Minister of Mine be ready for this move? From recent conversation we had, yes, the question was on the table. There is I wouldn't say you will see a radical U-turn for now, but yes, there is an opening to start building the conversation with the mining sector. And like I said, it starts by giving the companies the opportunity to learn more about Ohada, get a more awareness on what Ohada instruments in that field are and how they play and how successful they have been so far. I mean, this is all those steps we need to take to see a change in the mining sector.
Understood. Peter, I'd like to get from you your thoughts on this, I would say, comparison between Ohada arbitration and the other types of arbitration proceedings, and in particular the ICC or the ICSID. Tell us a little bit what are the pros and cons between the two, and how do you advise your clients when it comes actually to discussing about whether we should go for Ohada versus ICC or other forum?
Yeah, well, thanks a lot, Karim. And first of all, let me just say it's an honor to be on this panel. I mean, Achille and Jean-Claude, are very accomplished people in this area, and it's my privilege to be with you today. And it's a great panel to have because we each come at it from a different perspective. I look at it as a litigator. I mean, that's what I do. And, when people come to me, usually there's a problem. And we have to figure out how we're going to try to resolve it. Occasionally we get consulted on the, kinds of clauses that should go into a broader contract. Do you choose Ohada? Do you choose ICC? So sometimes we get consulted on that. Most of the things we do is usually things have gone terribly wrong. There's a dispute. How do we resolve it? By the time it lands on our desk, maybe we don't have a choice. Maybe there's already an Ohada clause, although people should know that it's sometimes possible, assuming the parties are cooperative, to roll into Ohada and that process. But I think the biggest problem for Ohada has been just lack of awareness by the general community. And I think panels like this, to what Jean-Claude said, helps educate people so that they become aware of it and understand what it is and the opportunities. There are pros and cons. I know there are people who talk about Ohada as if it's, the best thing going. Like most things, there's good and bad. And I think that, when we look at it, that's what we think about. We think about what's the good, what's the bad. When you're in litigation, what do you want to do? You want to find a cost-effective, reliable solution to the problem. If you can resolve it early through avoidance of, getting into a lengthy dispute in a hearing, that's obviously your first stop. If you can't do that, well, then you want to make sure that you've got a reliable panel. And at the end of it, if you win, you've got an ability to enforce your position. Ohada helps in all of those things. And, we talk about Ohada, but you've also heard this acronym CCJA, which is the actual, secretariat or the administrative body behind it, but also has a sort of what I would call a court-related process. For me as a litigator, what I like about Ohada is it's like a one-stop shop. You know, you've got a part of the world, a region of the world where there is a lot of poverty. You know, some countries like Cote d'Ivoire are actually quite, you know, relatively wealthy. Other countries are much poorer. There is a lot of certain parts are extremely dangerous. There's a lot of, you know, armed insurrection and strife. So if a mining company or an extractive industry company goes into these areas, you know, they're going to be thinking about these things. And the whole route, remember, the whole idea of Ohada was, you know, very, very smartly, these, you know, countries and the leaders came together and said, what can we do to give comfort to the international community by setting up a system that allows people to feel that they can go in, they can do business, and there's this process where they can have comfort in terms of the quality of the judicial opportunities or the quasi-judicial opportunities. They can have a one-stop shop, so they're not going into all the little countries and having to litigate. On paper, it's a brilliant idea. It's a great idea. Does it work in practice? I think it does sometimes. And, you know, if you have to litigate through it, by all means, you know, don't be alarmed by Ohada. If you're a mining company, if your opponent says, look, I want Ohada, to roll into the CCJ, I think that's great. It may not be the best thing for you, but it's just one of the toolkits. You know, and I think actually, you know, look, we talk about trends. I think one of the big trends right now in arbitration, generally in international arbitration, is the impact of the pandemic. And, you know, the fact that, you know, you've got an inability to move around the world that you did a few years ago. That's a pro and a con. And I think for Ohada, it may be an interesting opportunity. We see much more virtual hearings, Achille will know. I mean, he's an esteemed arbitrator. We see a lot more things happening virtually. We see a lot more business happening virtually. I'm sure everybody on this call knows exactly what I'm talking about. We're here virtually, as opposed to in Toronto, which is where, you know, where we normally do these types of conferences. That's an opportunity. I am seeing disputes managed virtually that we never would have seen before. And that, I think, is an opportunity for us. But, you know, if you're in an Ohada state, or for example, if you have to litigate this in Abidjan, Cote d'Ivoire, which is where these Ohada disputes usually find themselves being litigated, you have other challenges. You've got the ongoing difficulties in making sure that you've got people fully vaccinated in Africa, which is a tragedy in and of itself, but it is going to be a concern for a lot of teams that wish to go and litigate in that area. So we're in exciting times, but we're also in difficult times. You know, Karim, you asked about the pros and cons. Let me just quickly, if I can just quickly go through some of the high level pros. You know, I talked a little bit already about it, but let me just say at the outset, a pro can also be a con. When you go into this as a party, you know, what may appear to be a pro may be a con. For example, let me talk about cost. The cost of doing an Ohada type dispute, arbitration dispute, is so much lower than doing an ICC or LCIA type dispute in London or Paris. In fact, it's so low. Like yesterday, actually, just as I was preparing, you know, as I was reviewing to prepare for this yesterday, I went on to something called the Ohada cost calculator, just to put in some numbers. And then I did the conversion from the francs, the Central African francs. And I was looking at going, that can't possibly be true. It's so inexpensive. It's just unbelievably inexpensive. So most parties will look at that and go, well, that's wonderful. I mean, you know, all I need to worry about now is my super expensive lawyers. And, you know, if for any of you who've done arbitrations in London, I'm sure you've seen numbers that are eye-watering. But there's a disadvantage to that, which is it can affect the quality and the availability of arbitrators. It's actually been a case out of Ohada and the CCJ just on that issue. So often these things are a double-edged sword. The other thing is some parties, for example, a large mining company may say, well, you know, look, I can afford to have a dispute. Maybe tactically we're better off to force our opponent, you know, to go and spend a lot of money in London or Paris. There's nothing like the specter of expensive litigation to compel parties to think carefully about settling I mean, you want that too. So there's that. Another pro for Ohada is it's supposed to be faster. The timelines that are set are very impressive. But then there's also reports of a lot of backlog because the Secretariat has been underfunded. So, that may or may not be an advantage. There is the quality of the arbitrators and the lawyers who are involved is quite high. But whether or not that continues, time will tell. I mean, look, you've got to pay these people well. You've got to treat them well. The rules are they're ICC rules, basically, where as lawyers, we tend to be very aware of these kinds of rules, and that's good. So though, there's a lot of good stuff going on here. In practice, sometimes it isn't as good as we would like, but definitely it is one of the tools in the toolbox. You want to be thinking about it. Let me just say from a con perspective, language continues to be an issue. This is predominantly a French-based type. It's obviously predominantly a French area. I mean, Cameroon is a bilingual country, but it's predominantly French region. But it's recognizing that it should expand and be more English friendly or more Spanish friendly, because a lot of the companies that are investing, US firms or UK firms are more comfortable in English. It could be an advantage. I mean, Canadian lawyers, we're comfortable in both French and English. We're comfortable in civil law and common law. You tactically may want to go in there and just say, look, let's do it. But these are the kind of issues that you need to sort of think through when you're going into an Ohada type situation as a firm. Huge opportunities, but, by the way, enforcement, obviously, you get a judgment in one country, you can enforce it throughout. A huge opportunity. It may not matter for you. You may be just in Niger and, you're like, what do I care? But these are very, very important. And just one final thing to note, it's not just the cross-member state enforcement, but even within the country, the ability to enforce is much stronger there. I mean, I won't get into the details, but there are provisions that allow you to more rapidly get your judgment enforced at the national level. Now, again, in practice, it may not be quite that easy, but it's a big opportunity. Yeah, that you definitely, I think, have to put on the plus side.
That's very, very useful. Thank you, Peter. I'll be a little bit provocative. Would you say? I'm putting the question differently and very practically. People who are doing mining projects, on the research side or a corporation, they always say, "Well, is it bankable?" Okay. So my question is very, very blunt. Would you say that having a CCGA Ohada CCGA clause is bankable vis-a-vis the lenders, and what would be the argumentation to say or to respond to the fact that there's not a lot of case law in the CCGA, and we don't know whether the quality of the arbitration or the arbitrator will be there. We don't know whether the proceeding works well. I'm just playing the advocate of the devil, honestly. And I'd like actually to hear, in particular, Jean-Claude and Achille about, what should the people who are listening to us today, who are interested by this Ohada CCGA, respond to their lenders or development finance institution who are saying, for example, yes, we can do this, but not in this country for this or that reason. Achille, Jean-Claude?
Jean-Claude, sorry, I will take the first clause. Next time, I will give it to you. No, it's a very hot topic and very important question because the approach is very practical. When you are bargaining for a mining project, how you can convince the foreign investor to insert CCGA arbitration agreement. First of all, I want to raise out some facts. With regard of arbitrators, in CCGA, you can point the same arbitrators like as in ICC system, on ICSID system. You can choose your arbitrator on the panel or other people who are not in the panel. But I want to focus on one aspect which is not used to be highlighted, when we present water system. When you check the statistic of the case when an Ohada member was involved, what happened when the award was rendered. In this case, generally, the Ohada member countries try to set aside the awards. When we check no less than 20 cases, the award was set aside just one time. So in 20 cases, you just have one award. That means you can trust the work made by the judges, because generally people think that as CCJ have two caps, one as arbitration body, another as high court system in charge of setting aside the award issued under its auspice. It could be a matter of conflict of interest. No, you just have to check the case law. And when you check in statistic, you see we have 20 cases involving Ohada state or state entities, and the award which condemning an Ohada member country was set aside just one time. So for me, it's not a matter of the law is good, it's a fact. You can highlight it. You say, please check the statistic and make your own conclusion. I don't want to be very loud. I would just want to highlight this point because it's not well known. And we are not used to speak about it in conference. We have in the attendee people who are investing a lot of money in Africa. They need to know the result. And one other result is that when you have your CCJ award, it can be enforced in France. Many awards were rendered against an Ohada member state was enforced in France. I can give the case of a Cameroonian bank versus Equatorial Guinea. The award was recognized in France. Now they are trying to seize many assets of this country. So in terms of practical issue, we have to focus on two aspects: setting aside awards and enforcement awards. Even I know that there is immunity for execution in favor of Ohada state. It's not a matter of CCJ, because this immunity exists even you have an ICC award and an exit award. It depends where you want to enforce the award. If you plan to enforce the award in even is not another country during the negotiation and contract, please just insert a waiver of immunity. That's my point.
Thank you, Achille. Jean-Claude, as an operator and developer, what are your views? Are you sharing the same views as Achille's ones?
Yeah, just a quick comment here. And I hear both positions, and I guess Achille is right from the statistic perspective, but once again, it brings us back to the awareness, raising. The point is, and I will just take one example, as you mentioned, the lenders. We were building a project where we have Australian banks, part of the process. And I remember clearly the comment from those banks were strongly and robustly, emphasizing the fact that the convention with the states should stress on retaining international arbitrator. Yes, at this time, we didn't have that much statistic to build on, but the concern remains there. And it's always a matter of how far the guys could be familiar. Those institutions, international lenders will be familiar with the Ohada performances in terms of arbitration proceedings and arbitration decision enforcement. I think it's come back to these points. So this is one of the next journey we need to embrace, both as mining chambers, government together as an international investors, which are the mining operators in those countries, to raise the awareness about how Ohada could be part of the panel in terms of arbitration facilities available. That's a quick comment I would like to make here. Remember also, there is an historic component to that. From external parties, all of those was also associated with, those long-term political instability we had in some of those countries, our countries. Also, like I mentioned previously, the lack of specific expertise when it comes to the mining sector in terms of mining operations. I would just mention one area, when it comes to evaluating or assessing sale price, okay, on a mining assets. This is an expertise you don't find locally, or you didn't used to find locally. Now it's building up. So from all those historical bases, it was understandable for, external lenders to be more comfortable with things like, platform like ICC or others. So once again, this is what we need to build up. And I think this is all that we've started now.
Thank you. Thank you. Very, very helpful. When we see what's happening right now in Ukraine, what has been existing, across the continent. I was wondering, and listen, the perception outside of the continent, and in particular outside of the Ohada region, is very often not corresponding to the reality about what is going really on, on the ground. So, do you think that what happens right now with, I would say, this, resource nationalism risk is going actually to affect negatively the attractiveness of the Ohada arbitration process and proceedings? Do you see any risks that the global impact of this Ukrainian war, plus, I would say, the resource nationalism rising, could affect the attraction and of this Ohada arbitration? And don't you think that it's an easy argument to be made by people who simply do not trust? And let's be very honest between us. It's, as we say in French, pas de langue de bois. We need to figure out whether the current context, geopolitically speaking, may affect actually or actually delay the attractiveness of the Ohada arbitration proceedings. Perhaps, Peter, I know it's not I know that you've been heavily involved in this resource nationalism concept. I'd like to hear you first, if you don't mind.
Sure. Well, it's a good question. I don't know if I've got the answer, but why don't we start with this? Resource nationalism is something that's been growing for the last, I think there's been a trend line upwards over the last few years, becoming even steeper because of the pandemic. There seems to be, we saw, a certain element of nationalism over vaccine nationalism. And I think that's just spilled over into this sense that we need to protect precious minerals. And then there's been a development over the last few years of sort of a rise of more of a bipolar world geopolitically between China and the United States. China's very, very active throughout Africa in the mining space. For anybody who's on this call who does, mining type business, you know exactly what I'm talking about. So, the two large powers are finding themselves in conflict in this area. And then suddenly Ukraine happens. So I think it's too early to tell where that's going to take us, but conflict usually causes investors to pause for a minute and be very nervous. This is an area, the Ohada states are an area where there has been, in addition to what I've just talked about, an area where there's some very serious conflict, armed conflict on the ground. And that, I think time will tell as to whether or not that will increase as a result of what's now going on in Europe. Will, for example, certain state actors use this region as as another theater for their dispute, which sometimes, has happened. Well, we know has happened often in Africa, unfortunately, and other parts of the world. Does Ohada solve that problem? To me, anytime you have a tool that can bring comfort to investors, an alternative, an option where you've got, you're able to hold out a respected methodology for resolving commercial disputes, possibly investor disputes, although we haven't seen that really in Ohada. I think that's always a good idea. But, look, as advisors and those of us who are, corporations or executives in corporations in this space, I think you just have to be very, very cognizant that we're going to be in a period of change and flux. And things just got a lot more complicated. They were getting more complicated a month ago. If because I've done some of these panels on resource nationalism, and it's getting really, really complicated. Now, in the last week or so, it's just gotten even more complicated. And we just have to continue to monitor it and see, what do we do to give comfort to investors, to financiers. Talk about financing. Safety will always be an issue for people operating in the area. These are enforcement. These are all things that I think have just gotten a lot more interesting and complicated.
Thanks, Peter. But I just want to ask really, our friends Achille and Jean-Claude, and for the audience as well. I mean, there's a lot of shortcuts which are made by third parties who do not get really the perception and do not get actually the security of, the proceedings on the ground. Then they may think, look, if there is a resource nationalism action from whichever Ohada law country, why would I actually agree to have my issues with a state member of the Ohada resolved by the CCGA, even though, as Achille mentioned, you can have actual international arbitration. It's totally independent. But how do you break this, déjà vu or déjà entendu thing in the mindset of investors and lenders?
Well, if I just, before we turn it over to Achille and Jean-Claude, can I just say this, Karim? When there is a dispute in an Ohada country before the CCGA, if it involves, for example, Niger as an example, you're not going to have an arbitrator from Niger. By the rules state that it will always be somebody from another state. So the question then becomes, will those other people somehow do something that favors the other state? There's been one case where that was alleged. It was ultimately not found to apply. I think, look, I think it's a very good body. I think most people have come, most people who have any involvement with it, I think respect it. There is, the way it works is there's the arbitrators, and then there's in a way like a court over top of it where you could appeal. The risk is always there, I suppose, but we haven't seen it in practice. I think, I'm curious to see what the others think. Will companies be nervous in any event, prefer ICC or some other major group to resolve an investment dispute, for example? I think probably, quite frankly, if you're dealing with that kind of dispute, I think you'll see that. But we have to remember that there's piles of potential disputes that aren't of that magnitude. Often a lot of your disputes are with local suppliers, local companies. And I think people need to keep in mind that Ohada and CCGA are great for those kinds of disputes, where you don't need to have this massive type of warfare unleashed. Warfare, I mean, in the litigation sense. And for those disputes, it really is a very cost-effective and efficient way of resolving disputes, and should give comfort to investors who may say, is this going to be just a big headache for us? Are we going to slowly get drained of this investment because there are all these little disputes and you can't trust the local courts because, it's perhaps a patchwork of, for a variety of reasons. It really is a very effective way of dealing with those kinds of disputes, which most of the time is what you're going to be dealing with.
Thanks, Peter. Jean-Claude, Achille, I'm curious to hear you on this one.
Achille, shall I let you go? Or I'll take it. So if I may, just on this, historically, once again, and statically, we haven't seen, coming back to the resource nationalism, there is no such trend that we foresee. If I speak for Côte d'Ivoire, I mean, the country has an historic and a continuity of state sticking to its commitment, international commitments. So the trend is not there, but even if it would have been the case, and Achille will probably comment much better than I can do as a lawyer on this. I'm not a lawyer, but this type of risk is well covered from the mining convention we have, because the matter will then be, I mean, there's a clear path on how this is resolved in terms of, I mean, compensation. Then the issue will be in assessing the value to be compensated. And even there is a principle of, I mean, appointing experts to do the job. And so it's well structured in the mining convention we have. Peter is right on the trend of issues or dispute that will be going to the CCGA or equivalent locally. This will be usually dispute with your local suppliers or service providers. And for those, we're quite well equipped with not only the trade, the Tribunal du Commerce, trade courts, but also the CCGA could be an alternative to that. So, I mean, from a operator perspective, we don't foresee the nationalisms, I mean, the resource nationalism becoming a growing concern as far as Côte d'Ivoire is concerned once again. Maybe Achille can comment on those from a legal perspective.
Yes, first of all, I fully agree with you, Jean-Claude, because when we are talking about nationalism and in the mining industry in Ohada area, there is no example in the past years that even in DRC is not really in nationalism, but an issue raised when they enact the new mining code because they changed the duration of the stabilization clauses. But what's happened after the enactment of this code? The government opened discussion with mining companies and they find a general agreement for the implementation of this provision. But with regard to what you said, Karim, concerning nationalism and CCG arbitration, first of all, I want to remind a fact I didn't mention before. All the arbitrators appointed under the auspice of CCGA have the diplomatic immunity. That means an arbitrator who's acting under the auspice there is very comfortable versus any action we can be engaged against him by an Ohada member country. It's very important. It's very important. We adopt the same system of exit. And the second reason, Ohada is not a national court. That means when you are talking nationalism, for example, in Niger, it doesn't mean nationalism for Ohada. Ohada is an international organization with 17 countries. The nationalism for one or two countries is not the decision of the whole Ohada members countries. And the court is represented by the whole member countries. That means it's not because you have an issue. For example, with Niger, that means you can make any investment in Senegal. You greet us from Bamako. The political situation of Bamako is not the same in Kinshasa or in Dakar. So when you are preparing your investment and you are trying to assess the risk of your investment, it depends of each country. We don't have to make any confusion between the law, the settlement of dispute, and the political framework of each Ohada member country. the political risk of an Ohada country member is not equal to his neighbor. Now I'm in Niger. The president of Niger was elected by the population. Close to me in Burkina Faso, we know what happened. So we don't have the same political risk. There is no link with CCGA, even in the mindset of investor. And I understand your question. They continue to consider that if Ohada was created by some African countries, and we do not trust African countries for the settlement of dispute, that means CCGA is in fact but all the bad practice of the legal system in these countries. But CCGA is arbitration. We are talking about arbitration. The arbitrators are appointed by the parties. They are not only African. You can appoint an Australian arbitrator in CCGA is fully open. So if we really want to be scared by CCGA arbitration, please focus really on how the process is going on in Ohada arbitration system. Don't add any issues. We are important, but they are not linked with arbitration. It's a matter of mindset, and it's also a matter of Ohada state members. Why? When negotiating with an investor, it is your own duty to highlight the advantage and the performance of the Ohada arbitration system. It's normal. If you call me for an investment in China and you say, okay, let us go to a local court, I need information. And if you are not able to convince me about this system, I will refuse the arbitration clause you propose.
I think one quick comment I would also like to add to that, just in the sense of the general and shared fear people can have about resource nationalism as an emerging risk or an emerging topic we can see in the mining industry. It's good to see across the Western African countries that despite, and then you can even take a couple of decades back, despite the political change, but also instability you can see in the region, it is constant that mining sector has been kind of prevented or preserved from any of these resource nationalism attempts. And you see it in Burkina Faso, you see it in Mali, you see it in Côte d'Ivoire and other countries around. Yes, you can see here and there from time to time some contract revision, but the trend is that there is a high level of conscious from those countries that the mining resources are quite strategic to those countries' economy, so that the resilience we're talking about when talking about mining is also seen in the political risk side of things. So I mean, together with the countries, we kind of build up a very strong protection around the mining operations. A good example for that is the Randgold Tongon project in the northern part of the country. The project was developed in the middle of a rebellion period.
Yeah.
And the success of mining in risk coverage is that the company has been able to negotiate with the government, the sovereign government in the southern part of the country, but also the rebel controlling the northern part of the country, bridge in a kind of peace corridor which allow for the project to be developed while the rebellion was still going on. And there was at no point any political or sovereign risk potentially affecting the project. And we've seen that across Western Africa. I will come back to pandemic like Ebola a few years ago in Guinea. There was issues around those kind of projects as well. So you think of, you name the risk. This part of the continent and most of the countries have been able to develop protective measure when it's come to those strategic economic sectors. So that's also built on the risk coverage tools we're discussing this morning.
Yeah, thanks.
I want to make an additional comment, please.
Yes, Achille.
Sure. Yes. Let us go to DRC. One of the most important.
I was about to ask the question about DRC. Exactly.
One of the most important mining producer country in the world. How many companies abandon the mine because of the political context? If you continue the exploitation, why you want to focus your political risk in the country on the way of settling dispute? There is no reason. If you give this kind of reason, you are wrong and you are bad faith. Because if you really care about something, first of all, is the political system in the country, not the settlement of the dispute. And if you really want to address the issue, you have, first of all, where you are locating the seat of arbitration. It's another issue. Because if you want to locate even the seat of arbitration is located in our Ohada country, you can say, okay, all the meetings are abroad. I'm talking about practical issue because during the Ivorian political crisis 10 years ago, the issue raised. And what we see in arbitration proceedings, we say, okay, we have some difficulties with Ivory Coast to travel to Abidjan. It's not a safe country. Okay, it's just the seat of the proceeding on the legal prospect, but on the practical prospect, we are going to have all the meeting in Paris.
Yes.
Or elsewhere.
Yeah. Achille and all, I mean, I think that, as regard this research nationalism risk, there's always, the political risk insurance that can cover actually this risk of the structuring of the projects, such as the bilateral investment treaties. So I'm just trying actually to be voluntarily challenging here by saying to you guys, why the Ohada arbitration CCGA is not more present, and has not been developed. I heard you perfectly well. The audience heard you well. It's a kind of ongoing process. But two questions here: who are the best promoters of, the reliability of this proceeding? And do you think that there are other people, and I'm not naive, of course, I'm asking the question without being naive, but who else has an interest, basically, not to see this Ohada CCGA proceeding emerging and literally being more present in actually the mining contracts?
You are a very dangerous guy. You know that I'm ICC member, and you ask me this kind of question.
That's why I'm asking it. No langue de bois.
Pas de langue de bois.
Pas de langue de bois.
You want me to be dismissed for ICC court? No. To be serious, the fact is that if you take the example of ICC International Court, go to our website. How many events we organize every year to advocate the ICC arbitration system? There is a lack of marketing policy for CCGA. We have to be very honest, because I fully understand the mindset of someone who don't have any information concerning CCGA arbitration, and you telling, okay, we have to put this clause. Why may I accept? I don't know. I'm used to practice ICC, LCA, ICSID, or stock arbitration. Why may I switch now to Ohada? First of all, you have to showcase, to highlight the comparative advantage. And it's not a work of one shot. Every year, every month, you have to convince, to have discussion with people like Jean-Claude, because Jean-Claude is representing a mining company. We are not in the same position. I'm a lawyer. I'm aware of what's happening because I'm practicing CCJ arbitration. Jean-Claude is just a mining investor. So he don't aim to have dispute, but in case of dispute, why there's no meeting between the mining chamber of Côte d'Ivoire and CCJ? They are all located in Abidjan. For example, if they can convince, they can present exactly the system. They can organize opening door really. Let us go give to an inside view of the CCJ practice with our statistic, with our case law. They don't have any reason to hide what's happened exactly. As any system, I have some bad practice. I have to admit it, because if you want to improve a system, you want to know where is thing going on and where it's not going in the wrong way. But the fact is that Ohada in general and Ohada CCJ arbitration system, there is a lack of marketing policy. This is the first way. The second way is the scholar. How many paper are you used to see commenting award or decision relate, setting aside of award or enforcement of award? There are few, just some comments. If someone like Peters needs a decision, Peter, okay, well, Peter don't know where he can find documentation relate or other arbitration system. We are not talking about the provision, text, the rules. It's very easy to download the rules. We are talking about the practice, the case law. What about appointment of arbitrators, challenging of arbitrators? This is the hot topic now of arbitration. What about the disclosure of duty of disclosure of arbitrators? These are the main topic for someone who's negotiating a mining contract. If you don't give him a good knowledge in a practical prospect, not in a legal prospect, because Jean-Claude don't want to know legal prospect. It's not a lawyer, he's an investor. He don't have time to bug his mind with legal issues, practical issues. If I have a case, what will happen? Will you give me an example? That's the issue for me.
Thank you, Achille. Perhaps two more questions before we
probably a quick comment. Karim, if I may, a quick comment I would like to add here. I mean, preparing for this session, I went to the CCJ website as well, as just Achille was pointing out. Couldn't find any single decision I could just go through. I mean, in terms of, case law. You have to download something and then pay for it, or send someone to CCJ and get access to and pay for it. So it doesn't help the ordinary business corpus to be familiar with how CCJ can prove effective. The second thing is, from my perspective, your question would just help me redirect towards Achille and Peters. Because what happened usually, they are the one advising us. So we just raise questions. This is what we want to do. How do we can we do it? So I guess the first and at the forefront people to advocate and market the Ohada principles and advantage and this and that are Peter and Achille of this world. They are the one advising and they are the ones suggesting, because this is their field. So Peter will tell me what he's familiar with, what not only familiar, but comfortable with as a lawyer. If we had to end up in a conflict or a dispute, what is he comfortable dealing with? That's the world he would suggest me to live in. Yeah. So, that's part of the solution we need to address. So they are the ones who should start the process in terms of raising this awareness.
Right. I always, thanks, Jean-Claude. I always have the bankability item in my mind as a more transactional lawyer, and it's true that lawyers, even though they're convinced, about the relevance and the pertinence of this Ohada CCGA. Sometimes, some lenders, I'm not saying all of them, but some, I would say, stakeholders are not very receptive about the willingness for them to change the usual forum and tries, if you will, a new one, such as the CCGA. But I heard you very well. Perhaps two last questions on my side before we open up to Q&A. One is, and it's for you and also for the two others, but Jean-Claude, as an operational person and I would say as an investor, give us your tips on how you select the arbitrator. Is there any tips you may want to give to the audience, and what are the lessons learned on the basis of your experience?
Actually, on that, I don't have any specific experience of using an arbitrator so far over the last, 10, 12 years of the project we've been running. But from peers' experience, I think that the first item we'll be considering is the expertise of the arbitrator, because in mining field look quite specific, very sometimes very complex, and you need people who are mining led, mining operational led, with mining knowledge, with mining comprehension. Most of the arbitrators, I've been through the list of arbitrators from the CCGA, and they will usually deal with general matters, in law, general trade in law. But then when it comes to specifically dealing with, complex operations like mining, then you might be lacking those in that list. So you'll be, you tend to go outside. So that will be one thing. The second item will be the integrity.
Integrity.
Of integrity. Thank you. Of the arbitrator. I think that's quite critical when you are in an environment where justice and legal right and things of the kind can be sometimes fluid.
Right.
You need to make sure you're backing on a strong and integrity asset person. So, but those two things to stop here.
Great. Peter, perhaps the lessons learned for you actually in selecting arbitrators for Ohada law countries. Any lessons learned on your side?
Well, look, I don't think whether it's Ohada or not, I don't think the rules change with the selection of the arbitrator. There's a whole body of thought on the science of selecting arbitrators, and there are people out there who spend a lot of time. I think I wouldn't be surprised if there are even some firms are even doing psychological profiles of the arbitrator. Right. I don't subscribe to that, to be honest with you. I don't subscribe to that approach. To me, I think there's cases where people spend this time selecting their arbitrator, and then the other side will select their own, and then from those two you have the neutral third party, and they want to find somebody who's going to essentially be their advocate, a second level advocate. And look, there may be litigators out there who say, Mantas, you're out of your mind, that's so important. I don't buy it. I think, to me, you think about the fundamentals. You look for integrity. Jean-Claude talked about that. You like competence. Obviously, I don't want somebody who, clearly their personality is such that they're afraid to speak up. They're so shy they can't even speak. Because remember, if you're going to, assuming you have 3 arbitrators, you're going to have a room with 3 people who are going to get together. And most of the time, 99% of the time, they just want to do the right thing. They want to be fair and just. And if it's the 1% where they don't, well, you've got a much bigger problem. But let's assume you've got a fair and just group of people. You want to make sure that your arbitrator is going to be respected in that room, listens carefully, says what they've got to say, and has an opportunity to participate and be heard. That's what you want. And, if you have a bad case, you're going to lose one way or another. You should lose. It's the arbitrators will only go so far. You obviously want somebody who gets it, and sometimes it may not be a lawyer. Sometimes it may be a non-lawyer, but obviously somebody with legal expertise helps. if you have one arbitrator, it's a little bit different. If you have one arbitrator, I think, you are pretty much looking for the same thing, but, at that point, really the level of competence and patience to listen and understand. Increasingly, I think it's important to make sure you've got somebody who's comfortable with technology. If not, you want to make them comfortable, because that's the world we live in. I don't think there's some magic to this. A lot of this, I think, is just common sense, quite frankly.
Okay. Well, I think, thank you, Peter, and all. I mean, I think we have now 15 minutes to go, and I would like to open it to a Q&A, if any. Let me check. So far, gentlemen, you have pleased the audience because we have 0 questions.
Karim, can I suggest, while people are thinking about questions, that last question you asked me and you asked Jean-Claude, I'd be curious to get Achille's perspective, because, I think there are probably a lot of lawyers on this call who do also arbitration, and we have the opportunity to hear from somebody who's in that room, who is an arbitrator, who is in behind the scenes, to get, perhaps a perspective. What should the rest of us be looking for from a good arbitrator? What are the kind of things that he thinks makes for a good arbitrator? I think that
and don't say selecting Achille, please. Achille, don't speak for you. We all know that.
You really want to provoke me today. It's a hot issue. It's a very hot issue because the appointment of an arbitrator is, when you appoint a good arbitrator, is a warrant for the issue of the dispute, how the dispute will be settled. And the first thing I want to say is that generally people are used to appoint arbitrators because they are famous lawyers or famous scholars. 3 things. First, a famous lawyer or famous scholar is not a good arbitrator. Arbitrator is a matter of practice, first. It's a matter of specialization. That means the guy who's the best scholar, professor in everything is not. If the guy don't have any experience in arbitration, be careful. Be careful. Secondly, it's not because someone is used to practice arbitration, he can handle a case in mining industry. Because the majority of arbitrators, as said by Jean-Claude, are used to, they are familiar with general cases, business law, contract law, but they have never drafted a stabilization clause, for example. They don't know the stake of stabilization. And if you appoint someone like that, you can be surprised. And the third thing is language. When you have cases with 2 working language, not one, make sure that the guy you want to appoint is really fluent both language. Because sometimes, I remember some cases, I can't give all the details because they are confidential. What happened when we were deliberating, you are surprised. The guy is in the CV say fluent in English, fluent in Spanish, fluent in French. But now, when you have to check some document draft in French, the guy is not able to understand what's happening. You have to translate to him. And when you have an arbitrator, I translate to you as I understand what I have with my own mining. So if you want to appoint a good arbitrator, first of all, make sure that guy have an experience and what is the issue at stake. This consideration is more important in investment arbitration because in investment arbitration, we have many topics we are controversial. We have many controversial issues in investment arbitration. And if you really have cases involving this kind of issue, you have to know the mindset, the approach, because when you are counsel, you know the position of your clients and who can understand more easily in order not to help you, but to understand your position in the dispute and issue the best decision taken across all the stake of the conflict. For mining industry, is very, very important to make sure that the guy you are appointing is used to mining legal issues.
Let me ask you, bluntly, because as I said earlier, no langue de bois, and directly, do you think we need to consider personal characteristics? In other words, should we have a Ivorian arbitrator because the matter takes place in Ivory Coast, and because, for example, the client, the arbitration will be financed by a development finance institution such as the African Legal Support Facility, the AFDB. To what extent we take into consideration, or let me rephrase it, to what extent should we consider the personal threats of an arbitrator? What you've mentioned, Achille, works for, I would say, the international arbitration as well as the CCGA. But to what extent really we consider, for example, the ethne of this person, and because this person belongs to an ethne which is not well seen by the president of the arbitration court, should we take this arbitrator, even though we know is absolutely outstanding? You see my point, as I said.
Yes, I get your point very well. I get your point very well, and I will respond with two approaches, for international arbitration and for domestic arbitration. For international arbitration, the nationality of the arbitrator is very important. Let me say why. Generally, for mining dispute, the applicable law on merits is the law of the host country. If you appoint only people who are coming abroad, when they are deliberating, they are focusing generally only on the submission of the party. They don't care about the case law. We can change the award. We can change the reasoning of the arbitrator. It's very important. I'm talking about my own experience. I remember something like 3 or 4 cases when we were deliberating. The chairman, and when I was chairman, the co-arbitrator told me, okay, we don't care about the case law focus. I said, why? Why? We assign to settle the dispute under this law. That means we take in account the submission of the party, even with respect to the duty, not go ultra petita. We also have to check very carefully the meaning of this national law. And this issue is very important. Now we have many papers with regard to how our international arbitrators apply national law.
Okay.
So if you don't care about the nationality, the reasoning can go in the wrong way. For domestic arbitration, what we are talking about, tribe, is very important in Ohada area, because I know that I realize that, Karim, you have a good knowledge of the Ohada people. Now I understand what are you doing in Bamako.
We received some thanks Achille. It's very pertinent. Thank you. We received few questions. Let me ask you one which is a very good one. All of them are very good, but I'll select one. We haven't spoken about Chinese people and Chinese investors, right? And that's true. The question is, and I'm reading it, how do you deal with Chinese who seem to operate under their own rules, no matter what country they are in? For example, paying local officials bribes to operate illegally. Peter,
I think
you want to
that,
take this one?
Peter, go.
Yeah, look, well, first of all, let me just say this. I don't think that it's fair to say that Chinese companies pay bribes and operate illegally. I mean, I act for some Chinese companies which have some of the most stringent rules of any companies I've seen in the world. In terms of bribery and corruption, the ramifications of bribery in their own home country can be very serious. That's not to say that they don't do it, but there are non-Chinese companies. There are American companies. There's companies from across the world, Canadian companies that engage in that kind of behavior. So I do want to emphasize that I do not think it would be appropriate to focus on one nationality for the source of bribery and corruption. And in terms of bribery or corruption, look, that's not an arbitration issue. That's a broader criminal type issue. I think any company that does that is now, at risk, not only in the local country, but for example, the United Kingdom has very, very strict extraterritorial anti-bribery and corruption laws. I think we're going to see an increase in the enforcement of these types of things because there's just a broader desire to take steps against oligarchs, which will probably change the laws generally towards greater enforcement. I know it's very frustrating, though, for companies that, operate in these countries and then, their competitors go ahead and do bribes. I mean, that's a big problem. And look, I get it, but, how do you deal with it? I think it's not really an issue like what we're dealing with here. I think it's a different kind of issue. It's a criminal issue. I don't know if others on the Jean-Claude or Achille, if you have any thoughts on that.
No, for sure. Peter, I think you've responded, and I believe that. Not speaking with them. We have 5 minutes to go. What I would like to do, guys, and my fellow friends, I'd like to really have one takeaway from each of you to the audience on the basis of this panel. And obviously, we've been very ambitious in trying to address arbitration, in the Ohada low countries as regard mining project. It's a very broad topic. We'll need probably more than an hour and 30 minutes, but at least I hope the audience got some interesting insights. But as I would say, a summary and wrap up, I'd like to have Jean-Claude, Peter, and Achille, I would say, one takeaway for the audience, please. Jean-Claude, as a businessman, investor.
Yeah, thank you very much, Karim. I think one thing for me will be considering all the good, the strong advantages we've learned through the panel. CCGA will gain more than from advocating and marketing much better the CCGA arbitration platform, which we will gain to know better in terms of cost saving, but also time saving. So yes, definitely open for learning more on CCGA.
Thank you, Jean-Claude. Peter?
If you're entering into contracts with local businesses in the region or mid-sized businesses, I would very seriously consider putting in the Ohada system as your arbitral selection. For those kinds of disputes, I think everybody listening to this who's doing that kind of business should really seriously consider it. I think that's a very wise decision in most cases.
And Achille?
Yes. As takeaways, what I can say, Ohada need to be more advertised.
Yes.
Because they really have many competitive advantage. And Ohada not only advertise, Ohada need also to get in touch with businesses because they are the clients. If there's no dispute, there's no arbitration. So they have to be considered reliable in the mind of businesses. So we have to change the prospect of Ohada advertising, not only lawyers, but lawyers and companies. They are in all Ohada companies, they are mining chamber of mining chamber. And so I think it's time now to address these people in order to convince them that Ohada CCG arbitration is reliable.
Yeah, I mean, Achille, you're absolutely right. I mean, it's a question, and it's a matter of each and every stakeholders internationally, but more importantly, locally. And it requires a perfect communication, a perfect coordination, and a perfect collaboration between all of the stakeholders, and in particular, the ones that are located in the Ohada Low Countries. This is basically their forum, and they should promote it as much as possible. And between the international community and the local communities, we need actually to be aligned so that the projects are well-structured and easily bankable with this CCGA Ohada clause. I hope so. Anyway, we are coming to the end of the session. I hope you enjoyed it. Thanks a million to our great panelists. It's been a real pleasure to chair this session. Please don't forget that we have another session now today at 11:30 a.m. Toronto time, and it's going to be on critical minerals, Fasken seminar. Thank you, everyone. Have a nice week.